Hi, welcome to Inside Report. I'm Senior Investigator Bill Marshall with Judicial Watch, and I'm pleased to have with me today a phenomenal attorney, former Assistant U.S. Attorney and author, Sidney Powell, who is the author of this wonderful book, License to Lie, which came out in 2014 and is simply an outstanding expose of corruption in the Department of Justice. It was really a signal flare, I think, for what we are seeing today in the news, so much so that everyone is scratching their heads and wondering how our Justice Department could be as corrupt as it obviously is. Sidney, thank you for joining me today.
Oh, thank you. It's a pleasure to be here.
In your book, you outline so many incredible stories of the abuse of the prosecutorial system and by prosecutors who I'm surprised are able to practice. I'm surprised are not in jail, let alone still able to practice law. And we could just hit on some of these. I mean, we could sit here for hours and discuss your experiences dealing with the Justice Department on the other side as an appellate attorney. But of course, you sort of grounded you honed your teeth, as it were, in the Justice Department. Can you tell me a little bit about your days working at DOJ?
Well, it was a long time ago, but I worked for 9 different United States attorneys in 3 districts across the country, and they were from both political parties. They were all, it didn't matter to us who the president was or what the politics were. Every one of them, down to the last person, said, just apply the law to the facts. Don't make up anything. We don't need to go looking for things to make up or people to target like is happening so much now. There's more crime out there than you can say grace over. Prosecute the real crime. And that's what we all did. Fast forward, I'm in private practice 20 years later, roughly, and start seeing what I saw that I detail in the book, this core group of prosecutors that were willing to break the rules simply to achieve political or social objectives. And they made up crimes. They hid evidence that showed people were innocent. They destroyed Arthur Anderson and 85,000 jobs, only to be reversed by the Supreme Court 2 years later, 9-0. A unanimous Supreme Court decision. And people want to say it's just because the jury instruction was flawed. No, it's because they took 2 different statutes and pieced them together to make a crime out of something that wasn't.
Right.
And they knew that's what they were doing.
Right. And you start off your book actually talking about the suicide of a prosecutor, Nick Marsh, who was eventually, I guess he was the lead attorney in the prosecution of Senator Ted Stevens. And
yes.
If you could discuss that case for me a bit, that was really remarkable what they did to that man, to Ted Stevens, who was a World War II fighter pilot, as I recall. He was a hero.
Distinguished Flying Cross recipient. He was a World War II hero. He's in the World War II Museum in New Orleans.
Right. So what was the background of that case, if you could tell me a little bit about that?
Well, they tagged him on some silly supposed ethics violations. But come to find out, they again had hidden the evidence that showed he was innocent and that contradicted their witnesses. They managed to get a jury to convict because all the evidence they knew existed they managed to hide. But a whistleblower named Chad Joy with the FBI filed a complaint finally. He just couldn't take it anymore. He was the youngest agent on the squad, and what he saw really troubled him. And Judge Sullivan got wind of it, despite the FBI and DOJ's best efforts to keep that suppressed as well. And when he did, it was clear that Judge Emmett Sullivan here, who also has the Michael Flynn case now, was going to turn the tables on Department of Justice, throw out the conviction, and that's exactly what he did.
And wasn't evidence essentially fabricated in that case? Just to step back a little bit, he was accused, I think, of accepting gratuities, was that it, or
construction? Supposedly, the construction of remodeling costs on his house was inflated or the guy had done more work than supposedly actually was done.
Right. It's like $200,000. Senator Stevens was accused of accepting work totaling $200,000, and you actually point out in your book that you're a serial remodeler. I like that
Yes.
phrase yourself.
That's what my son calls me.
You looked at the home and said that was not $200,000 worth of work, and maybe $80,000 or something was the actual value, and that there was actual, as I understand, as I recall from reading the book, there was actual evidence essentially fabricated in that case.
Yes. And meanwhile, they hid the contractor, and people had horrible records. And Senator Stevens had written a note telling the contractor to be sure to bill him, that he, had to and wanted to pay all the bills. And they made that sound like it was a wink and a nod. Mm-hmm. The way they avoid providing exculpatory evidence to the defense is by saying, oh, well, if it's favorable to the defense, it was said with a wink and a nod.
Right.
So that makes everything inculpatory. It's an unusual view of the world.
Right. Exculpatory evidence obviously being evidence that would show the innocence of the defendant.
Yes.
And inculpatory being evidence which would implicate them in some kind of criminal activity. And this is a chronic, as you document so well in so many cases in this book, this is a chronic problem within DOJ. I mean, as you and I have discussed before, a quarter century ago, I worked for a few years in DEA, which is part of DOJ, and I viewed the government as essentially a force for good, and we are. It's employees honest, hardworking, and seeking to bring justice, as is implied in the title Justice Department, right?
Yes.
After reading your book, I mean, of course, I've become much more cynical in the years since then in my role as an investigator of the government. Now working for Judicial Watch, I'm much more jaded, obviously, and so it doesn't come as a complete shock as I think it might to the average American to a greater degree, the scope of the problems within the Justice Department that you reveal so well in this book. But this notion that these prosecutors are so career-driven and so hell-bent on getting a conviction and thereby getting a feather in their cap and getting themselves promoted, that they will actually send innocent people to prison at times for crimes that are either non-existent or that are for which they are not guilty. And another example being another individual that you represented, which was a Merrill Lynch executive named Jim Brown. Maybe you could tell our audience a little bit about his case.
Well, Andrew Weissmann was head of the Enron task force for a while, and under him worked Catherine Rumler and Matthew Friedrich. They were part of the team that destroyed Arthur Anderson. Rumler was not on that. She didn't come in until time for the Merrill Lynch case. But they indicted an innocent business transaction. They can make an innocent business transaction sound like an international crime of extraordinary magnitude, and that's exactly what they did here. And in the process, they sent 4 innocent Merrill Lynch executives to prison on an indictment that, again, made up a crime and made this business transaction sound like something horrible. The 4 innocent Merrill Lynch executives spent up to a year in prison. One of them spent 8 months in a maximum security federal transfer facility with the worst of the worst. He was our youngest Merrill Lynch executive. Seth Waxman represented him on appeal and got him completely acquitted.
Right.
The others should have been acquitted. Mm-hmm. The court just wouldn't go that far, but effectively they said they had charged conduct that wasn't criminal in the indictment. So you can indict and convict a ham sandwich and send it to prison on absolutely no basis. We couldn't even get them bail pending appeal. That's why they had to go to prison immediately upon their convictions.
Yeah.
And they were eventually released, but the damage, I mean, you can't undo sending an innocent person to prison.
Well, that's what's remarkable to me, that how relentless DOJ was in pursuing charges against your client.
It was the Enron task force.
Right.
It was that, and that cabal of prosecutors was hand-chosen by Bob Mueller and Michael Chertoff, and Larry Thompson, because they were terrorists of prosecutors. Well, that's not what a prosecutor's supposed to be.
Right.
A prosecutor is not supposed to have skin in the game. They're not supposed to walk in a room and say, you're going to tell us this, or you're going to be indicted, which is exactly what Leslie Caldwell did.
Right.
And she became Loretta Lynch's head of the criminal division of DOJ. Matthew Friedrich became the head of criminal division of DOJ under Bush, and he's the one who micromanaged the prosecution of Senator Ted Stevens. Right. And then all the others were promoted by President Obama. Weissmann became general counsel, deputy director of the FBI. He's been protected by Robert Mueller for at least 2 decades. And Lisa Monaco, who was implicated in misconduct in the Enron broadband case, that was horrible. A lot of people were acquitted there. They prosecuted them up to 3 times.
Wow.
Yeah, so even if you got it reversed, and that happened to my client, we got it reversed, they were coming after him again. And that's when I discovered, after 6 years, the evidence that they'd actually yellow highlighted before the first trial, but hidden, that showed he was innocent, and that they knew it was an honest business transaction from the beginning.
Incredible. And then all these people, as you say, Robert Mueller was painted as this paragon of virtue and nobility because he had served, to his credit, as a Marine officer, as I recall, in Vietnam. But that doesn't give him then carte blanche to lead a career of as you say, of legal terrorism and warfare and rising to the heights of our government and the process.
Exactly.
I mean, and he brought in this gentleman, Andrew Weissmann, as you say, to lead the effectively lead the special prosecution team going against President Trump, when he had a documented history, it just from the accounts in your book, of engaging in prosecutorial abuses that I don't see how they could not land him in prison.
Yep, putting people in solitary confinement until they said what he wanted them to say. That happened to Enron Treasurer Ben Glisson, who was a 35-year-old man, voluntarily reported to prison to serve his time, and suddenly found himself in a hole, literally, with a slit for light. And the UN and the ACLU have decried solitary confinement as torture. It is. It'll drive a sane man insane within 24 hours. People will say anything to get out of there, at least, when people that were sane when they went in will. And certainly Ben Glisson was, nothing in his life equipped him for that. But Mr. Weissmann wanted him to sing to the grand jury, even though he had just pled guilty and wanted to do his time and be done with it. That wasn't sufficient.
These are third world tactics. I mean,
yes.
We throw that term out a lot, especially here, because we see so much of this kind of stuff, banana republic kind of stuff. But this is really what this is. These are show trials, effectively, that the U.S. government is putting on. And what comes across very clearly in your book is your love for the Department of Justice.
Yes.
As a young prosecutor
Thank you
yourself.
for recognizing that,
Yeah.
because it's true. I mean, I wrote this book out of love for the Department of Justice and what the justice system is supposed to be.
Clearly. And I'd like to think, that there are, and as critical as I am in my own writings and of the FBI and other federal law enforcement agencies, I remember my own years working in the federal law enforcement community with fondness. I still have friends, dear friends, after decades that I regularly meet with and that I work, in law enforcement, federal law enforcement still, or that are retired from there, and they're equally shocked, even the ones that are still in. So I am convinced that there is. I like to think that the vast majority, I don't even know what
it
percentage.
may be about 50%. now.
Right, but are honest, hardworking, dedicated civil servants who are pursuing justice and not career advancement.
Or an agenda. I think a lot of this was a certain political or social agenda.
Right.
And then the Obama administration took it to the nth degree, weaponizing and politicizing every single federal agency to achieve social and political ends.
It's amazing. And you alluded earlier to the destruction of Arthur Anderson. That's just I actually have a sister-in-law who worked for Arthur Anderson as a young accountant, and she was already gone by the time that the company imploded. But here you had what was considered the gold standard of public accounting. I believe, if I'm not mistaken, there were about 85,000 employees.
Exactly, worldwide.
It set the benchmark for accounting. And you have the Enron Task Force, Weissmann et al., create a phony charge. Now, what was the charge? What was it they were accused of? That Arthur Anderson was accused of again?
They were accused of obstruction of justice via the witness tampering statute that was supposed to somehow play into shredding documents.
Right.
So none of it worked. I mean, as soon as I read I'd paid no attention to the Anderson case at all. I mean, I just have never paid attention to politics. Thought, like everybody else did from what I read in the press, that anybody related to Enron was just horrible. And I used to think our press was accurate too.
Right.
Oh boy, I got into that case and I got a whole new education about what was going on in the world.
Right. So just by virtue of the fact that they were indicted, effectively destroyed the company.
Yes,
right?
And they knew that was going to happen, so they sealed the indictment for a week while they worked behind the scenes to avoid upheaval in the markets, because Anderson represented 2,500 publicly traded companies, and they, of course, couldn't do that, and they were afraid there would be a massive market crash if it came out just suddenly that Anderson was indicted. So they knew exactly what they were doing.
Incredible. So they destroy one of the premier companies in the United States just to fulfill a political goal.
It was a power play.
Yeah.
And I heard that President Bush himself authorized the destruction of Anderson.
Amazing. I just.
And that meant that every company whose door they knocked on thereafter had to give them whatever they wanted, or they would be destroyed too. And for Merrill Lynch, that meant sacrificing 4 business executives and allowing an Enron task force supervisor to be inserted into Merrill Lynch for, I think, 18 months, and signing the most unconstitutional non-prosecution agreement I have ever seen.
Wow. Yeah. And now, of course, you're representing General Flynn. I'd love to be able to know what's going on in that case to the extent that I understand that you can discuss it.
Yes.
Now, his business partner, Bijan Rafikian, right?
Yes,
Is that how you pronounce
that is.
Mangle his name. His case was just dismissed, as I recall.
It was, yes. Judge Tringa in the Eastern District of Virginia granted a judgment of acquittal on the conspiracy count and the Section 951 violation, which charged him with being an agent of an agent of Turkey, subjected to a 10-year federal felony, when all these guys did was write an op-ed that was published in The Hill.
Right. And in fact, you and I were discussing a couple of days ago, I guess, your view that FARA, the Foreign Agent Registration Act, is unconstitutional? Is it?
Well, until Mueller came along, it had been enforced only civilly. And of course, remember that it was charged against Manafort, and I think one of the Podesta brothers was named in the indictment. He either got immunity or nothing happened to him, but then look what happened to Manafort.
Right.
And then at the last minute, right before General Flynn was to enter go to his sentencing in front of Judge Sullivan December 18th of last year, they suddenly indict the Rafikian case in the Eastern District of Virginia. And that's another one I looked at, well, actually not until I got into the case with General Flynn, but I saw what they were trying to do, and it made no sense whatsoever.
Well, that brings up a whole nother issue. Is this unequal application of the law, which again goes to this banana republic sort of template that we seem to be following now in our country. Which to my mind, it's shocking and just very depressing. I mean, to think that, in our country, you are prosecuted based on what political party you belong to, and
exactly.
what political philosophy you adhere to, who you associate with, potentially, or if you happen to be in the way of some political agenda that's, like in the case of all those Arthur Anderson employees, you just happen to be in a job that in which your company suddenly becomes the target of the government for whatever reason. Now, what do you think this Mr. Rafikian's dismissal of his case portends for General Flynn's case? I would think it's a good omen for you.
Yes. Well, part of the statement of the offense that he pled guilty to includes an allegation that there were material false statements in the FARA filing. It blew up in the Eastern District of Virginia when the prosecutors there, including Mr. Van Grack, who is still prosecuting Mr. Flynn now, was determined that Mr. Flynn testify that he knowingly and intentionally signed a false FARA registration. Well, he didn't, and the statement of offense doesn't say that. In fact, I just recently found the draft of the statement of offense that shows that that language was taken out. So Mr. Van Grack and I got into a heated exchange. He was on the speakerphone. I was with like 6 assistant U.S. attorneys in Eastern District of Virginia, in which I explained to him that General Flynn was not going to lie and to say that. And he said, "Be careful what you say. You don't know who's on this phone call." And I said, "Put the world on the phone, Mr. Van Grack. Just put the world on it."
Right. Good for you, and you're not the type to back down or to be intimidated.
Yeah, and then I wound up filing in Judge Tringa and Judge Sullivan's court essentially a transcript, or at least the notes that had been taken by our note taker of that meeting and that whole exchange, because the judges needed to know exactly what was going on.
Wow, that's great. So I think that General Flynn is probably pretty confident now that you're representing him that the future looks brighter.
He feels much better. I mean, I've identified significant Brady violations in the case, not the least of which is a January 30th internal memorandum in the Department of Justice that clears him of being, quote, an agent of Russia, end quote, which is apparently the first thing they pretextually investigated him for. Even though he was working with the DIA on all his foreign contacts, they've suppressed that information from us. There are substantial reports by a number of DIA officers about his briefings and debriefings, and that's classified, so they've denied me a security clearance and any access to that information. I'm like the last person in the world who wants to have a security clearance to find out what's really going on. Right.
Well, that's like they're using all the tools at their disposal. I mean, they're holding they're holding a lot of the cards. I mean, not all of them, but they certainly have advantages that as the government with control over the issuance of security clearances and everything else to make your job that much more difficult.
But what really infuriates me is they're hiding the truth.
Absolutely.
We can't solve any problem in this country until we know what the actual problem is and what the truth is.
Right.
There is an objective truth there.
Well, it seems to me you're very fortunate to have Judge Sullivan on the case, and he comes out as a real hero in your book. I mean, we don't. We deal with Judge Sullivan a lot in our FOIA litigation, as you know, and sometimes, we get a favorable ruling. Not all the time. We don't always agree with his rulings, but he does seem eminently fair. And you certainly, as you highlight in the Stevens case, he excoriated the prosecutors in that case, and actually brought in a special prosecutor, Schulke, I believe.
Yes, Hank Schulke.
Right, to look at the prosecutors who were involved in going after Stevens, and of course they were going to hang the whole thing, that whole case, all the anomalies, if you will, all the misconduct on the lead attorney, Nick Marsh, the young man who
had been replaced at the last minute.
Right, he was demoted to third chair, but somehow I guess was it Rita Glavin and
Matthew Friedrich were the ones calling all the shots, literally micromanaging the whole prosecution to the point of who stayed in what hotel room.
Right, but Judge Sullivan was not aware of their involvement, as I understand it. Right?
Yes,
their names were not on the filings and so forth. So. Wow. So Nick Marsh feels all the heat coming down on him. He knows he's going to be the one with this, hung out to dry, as it were, and the pressure builds, and sadly he
committed suicide.
He committed suicide here in D.C. right in 2010, I believe it was. Very, very tragic. I would have thought that after Judge Sullivan's speech in the courtroom, in which he just, which was blistering, where he just laid into those prosecutors in Stevens' case, that there would have been a sea change at the Justice Department in terms of treating Brady material.
You would think.
Again, the Brady material being evidence that the government is required to release to the defendant and their legal teams, which would demonstrate the innocence of the defendant in any given case. But there has been no change. I mean, this from what I can see, it's just as
it was pure lip service. I mean, we can tell that by the fact that there were 2 cases related to the Stevens prosecution that involved the same witnesses and the same absence of production of exculpatory evidence. They were the cases of Cott and Coring in Alaska. Well, despite the incredible rebuke in the Stevens case, the prosecutors in that case, who were also related to this there was a polar pin task force is what they called it for that prosecution. They went to the judge there and claimed that the evidence that had been withheld, same evidence, same kind of case, same everything, they said it was not material to the outcome of the trials. That's their fallback position. It's not material. It doesn't matter to the outcome. It wouldn't have changed the outcome of the trial if they'd produced it. And they got the district judge out there to buy that.
Right.
Well, fortunately, the Ninth Circuit has been more tuned in to prosecutorial misconduct than some of the others. And there was a blistering decision by 3 of the judges in the Ninth Circuit, including a concurring opinion by Judge Betty Fletcher, that just tore them a new one.
Well, how do you see this changing? I mean, how going forward, how do we ensure that federal prosecutors in the future, release Brady material? I mean, is there some new law that has to be enacted?
It could start a number of ways. Federal judges could do it now themselves. Judge Sullivan has entered, and he does in all cases, a robust standing Brady order. What's going to be really interesting is to see how he enforces that in the Flynn case, because out of the box, I filed a motion to compel production of Brady material and a motion to hold the prosecutors in contempt for their failure to produce it, because I've been asking for it since actually 3 days before I appeared in the case, I wrote a letter asking for it. So they are on notice of everything that I was asking for, and they just thumbed their nose at the order and said, oh, well, he pleaded guilty. Well, Brady applies whether you've pled guilty or not. And Judge Sullivan's order makes that clear, so they don't get to sail by that one. And if he really enforces this order and holds them in contempt, that would be a huge step forward. But every judge in the country needs to do that. And unfortunately, despite the Stevens case, which is now almost 20 years ago, I guess, judges don't have the healthy skepticism they need of the prosecutors.
Right.
There's still, prosecutors get whatever indictments they want. Grand juries need to be better educated. Prosecutors need to have some skin in the game in the sense that right now they enjoy absolute immunity from any civil action against them. They could deliberately send you, an innocent person, to prison on a completely made-up crime while they hide the facts that show you're innocent for the rest of your life.
Right.
You could be cleared 25 years from now. There's nothing you can do.
Right. And in fact, you pointed the wonderful thing. One of the wonderful things about your book is that you name names. And you describe people in sometimes less than flattering detail, put it that way, their personalities and so forth. And I've just thought to myself after reading this book, I'm thinking, boy, how do you continue to work with some of these folks that undoubtedly you have to continue to interact with in your profession? But one of the names you name is Judge Werlein, I think is
yes.
his name. And he oversaw. Did he oversee the Jim Brown's case?
Yes, he oversaw the Merrill Lynch case. Literally, he's sending these guys to prison, saying, I understand you were just doing your jobs that day and you didn't take any money from anybody, and Enron didn't lose any money on the deal, and Merrill Lynch only made $775,000.
Amazing.
Enron made $53 million on the transaction.
Right.
So there was no loss to shareholders, but the government wanted to tag us for the entire collapse of Enron, which ratcheted up the sentencing guidelines ginormously. Mm-hmm. The whole thing was ridiculous.
And he kept accepting the prosecutor's claims that they had turned over all the Brady material,
oh, yes.
right? He took them at their word with no, despite evidence that you presented, if I recall correctly, that was fairly demonstrative to the contrary. Right?
And even when we showed him 6 years later the yellow highlighted evidence that they knew contradicted their case, that they had deliberately yellow highlighted before the first trial and hidden, he wrote a 66-page opinion that didn't even mention the yellow highlighted evidence.
Wow.
Yeah.
So that's not a good sign. I mean,
No,
it's not a good omen.
it's not.
And I can't. It's wonderful that we have these outlier judges like Emmett Sullivan and perhaps Royce Lamberth, who's hearing our Benghazi
And
talking
Judge
points
Tringo, but
case.
it should be every judge.
It really should.
They've got to throw out more cases on motions to dismiss indictments. They almost never do that, and that should have happened in the Merrill Lynch case. That should have happened in the Anderson case.
Right, which again, which just raises in my mind the possibility that there could be some kind of institutional reform, which wouldn't leave it so much up to the discretion of the judges. But I mean, I don't know how else exactly you would codify something like this, but some way to ensure institutionally that this kind of information gets produced.
Well, Harvey Silverglate and I have joined together to write a new book called Conviction Machine that we hope will be out in the next 9 months or so.
Wonderful.
In that we propose solutions for fixing it, not the least of which is to have Congress abolish absolute immunity, at least put an exception in the Federal Tort Claims Act so that prosecutors who commit intentional misconduct can be held accountable civilly for it.
Excellent. I assume that there's going to be a Michael Flynn. I'm guessing, but I'm pretty somehow. I get the feeling that you're going to get General Flynn off, and I hope that there'll be a book forthcoming about his whole saga, because that would probably fill volumes. Everything he's been through.
I'm sure he would probably want to write one, and I will definitely have to write one.
Yeah.
Because this cannot keep happening.
Right.
Prosecutors have unbridled discretion. They have no supervision. The judges need to step up and do their jobs. We need a new culture, too, in the Department of Justice that goes back to the old one that I was raised under.
Right. Well, that actually, you raise a great point. This is actually bigger than the Department of Justice. You touched on it earlier, but we're seeing the weaponization of all of these federal agencies. I've been fortunate enough to be involved in much of Judicial Watch's work relating to all the abuses at DOJ and CIA, State Department, relating to this falsely predicated, I would argue fraudulently predicated counterintelligence investigation against the Trump campaign.
Yeah, they made it all up.
Yeah, they did.
I knew what was going on as soon as I heard the first parts of it.
Yeah, in fact, I had written a column probably a number of months ago when William Barr was first named Attorney General, called "It's Up to You Now, General Barr," which I think that was the title. I think it ran in Town Hall, where I basically said that the foundation of our constitutional republic is effectively fractured right now. And he is really the one guy. Can't be President Trump because it would be viewed as too political. But the Attorney General is the one man, I think, who can save the republic, who can repair that foundation. In fact, I equate him in my column to Ulysses S. Grant in the Civil War. He was essentially the one man who was able who had the fortitude and was able to marshal the forces in such a way to finally win the war and bring it to a successful conclusion. Well, Sydney, I can't thank you enough for joining us today and your work, both as you've outlined the gross abuses within the Justice Department in this book is just phenomenal. Again, the book is License to Lie, Sidney Powell. It's subtitled "Exposing Corruption in the Department of Justice." Great book, and you could write volume 2 and I'm sure that'll be forthcoming, as you say, with your new book with Henry Silverglate, and perhaps one about the Flynn case. Thank you all for joining us. Thank you, Sydney.
Thank you.
And if you'd like to support our work, which is your support is vital to Judicial Watch's mission, you can go to www.judicialwatch.org, and you can also follow us on Facebook and Twitter and share our articles with your friends. Thank you.